I was sitting on my back deck in Chandler, Arizona, enjoying my Saturday morning coffee when I noticed construction equipment on what I knew for certain was my property. Not near the property line, not straddling some disputed boundary. Fully, completely, and undeniably on my land. A good 15 feet past where my surveyed property markers clearly indicated the edge of the common HOA area. 3 workers were digging a massive pit, and stacked nearby were pallets of decorative stone, metal fire pit components, and landscaping materials. My name is Marcus Webb, and I had lived in the Saguaro Springs subdivision for nearly 8 years. The HOA and I had what you might call a complicated relationship. They were the kind of association that measured grass height with rulers, sent violation notices if your trash cans were visible from the street for more than 2 hours after pickup, and held emergency board meetings if someone dared to paint their front door a shade that was not on the pre-approved color chart. I had learned to navigate their bureaucracy, kept my property immaculate, and generally stayed out of their way, but this was different. This was not some petty complaint about my mailbox placement or the wrong shade of beige on my shutters. This was construction happening on my property without my permission, without notification, and without any legal right whatsoever. I walked down from my deck, still holding my coffee mug, and approached the workers. The morning sun was already heating up the desert air, and the 3 men were sweating as they operated a small excavator. "Excuse me," I called out, raising my voice over the machine noise. "Can you tell me what you are building here?" The operator shut off the excavator, and an older man with a weathered face and a company logo on his shirt approached me. "Community fire pit," he said, pulling a bandana from his pocket to wipe his forehead. "HOA-approved project. Should be real nice when it is done. Going to have seating all around it, decorative lighting, the works." "That is interesting," I said, keeping my tone measured, "because you are building it on my property." The man frowned, looking uncertain. "No, sir, we have the plot marked out." "This is common area land according to the plans the HOA gave us." "The HOA gave you incorrect information," I replied. "I had this property surveyed when I bought the house, and I had it resurveyed 3 years ago when there was a dispute about my fence placement. I have iron stakes marking the corners, and if you look right there," I pointed to a spot about 15 feet south of where they were digging, "you will see one of those markers. This is definitely my land." The contractor looked uncomfortable now. He pulled out a rolled set of plans from his truck and spread them across the hood. "Look, mister, I do not want any trouble. The HOA hired us, gave us these plans, and we are just doing the job we were contracted to do." I examined the plans, and immediately I could see the problem. Someone had drawn the property boundaries incorrectly, showing my back lot line much further north than it actually was. The error was not small either. It was off by at least 20 feet, which in property terms was enormous. "I understand you are just doing your job," I said. "But I need you to stop work immediately. You are on private property without the owner's permission. I am that owner, and I am telling you right now that you do not have permission to build anything here." The contractor sighed deeply, looking at his crew and then back at his plans. "I am going to need to call the HOA contact. This is above my pay grade." "You do that," I said. "But in the meantime, I need all work to stop. If you continue, I will have no choice but to call the police and report trespassing and property damage." The contractor made his call, stepping away for a private conversation that involved a lot of animated gestures and head shaking. When he returned, he looked resigned. "The HOA president, Linda, wants to talk to you. She is on her way over right now. She said we should continue working until she gets here and sorts this out." "That is not how this works," I said firmly. "I am the property owner. The HOA president has no authority to authorize construction on my private land. Work stops now or I make that call to the police." The contractor looked at his crew, then back at me, weighing his options. Finally, he waved his hand at the workers. "All right, guys, take a break. Let us get this sorted out before we go any further." I went back into my house and retrieved my property survey documents, the deed to my home, and my file of previous correspondence with the HOA. Over 8 years, that file had grown thick with violation notices, meeting minutes, architectural approval forms, and various disputes. I had learned early on to document everything when dealing with the Saguaro Springs HOA. Linda Morrison arrived 20 minutes later in her white Lexus SUV, parking it aggressively close to the contractor's truck. Linda was exactly what you would picture when someone said, HOA president. She was in her mid-50s, always dressed like she was heading to a country club luncheon even on a Saturday morning, and had that particular hairstyle that required speaking to multiple managers to maintain. Her homeowners association tenure had lasted 6 years, during which she had ruled the subdivision like a small fiefdom. She marched across my lawn with her phone in one hand and a folder in the other, her heels aerating my grass with each step. I met her at the property line, my own documents ready. "Marcus," she said, not bothering with pleasantries. "What is this nonsense about stopping our community improvement project?" "Linda," I replied, matching her tone. "What is this nonsense about building on my private property without permission? This is common area land," she said, flipping open her folder and thrusting a map at me. "According to the subdivision plat, this entire area is designated for community use." I did not even look at her map. Instead, I held up my survey documents. According to my professional survey, which was conducted by a licensed surveyor and filed with Maricopa County, this land is part of my lot. My property extends to here. I pointed at the iron stake, and then runs along this line. Your fire pit is entirely on my land. Linda glanced at the survey, her jaw tightening. This survey is wrong. Our records clearly show your records are incorrect, I interrupted. The county has my survey on file. It is legal, binding, and accurate. If you had bothered to check with me or look at the actual filed property boundaries, you would have seen this before you started construction. We do not need to check with individual homeowners for community improvements, Linda said, her voice rising. The HOA has the authority to make decisions for the betterment of the entire neighborhood. Not on private property, you do not, I said. You have authority over common areas and to enforce deed restrictions. You absolutely do not have the authority to seize private land for your projects. Linda's face was flushing red now. This is ridiculous. We have already invested thousands of dollars in planning and beginning this project. The entire community will benefit from this fire pit area. You are being selfish and obstructing progress. I am protecting my property rights, I corrected. Something I have every legal right to do. If you wanted to build this fire pit, you should have built it on actual HOA common land, or you should have approached me about purchasing or leasing this portion of my property. You did neither. You just assumed you could do whatever you wanted. The contractor was watching this exchange with obvious discomfort, staying near his truck and probably wishing he had taken a different job that morning. Linda pulled out her phone and made a call. I could hear her side of the conversation clearly. "Robert, I need you at the fire pit site immediately. We have a situation with Marcus Webb." She paused, listening. "Yes, that Marcus Webb, just get here now." Robert Chen was the HOA's attorney, a man who I had encountered several times over the years during various disputes. He was generally more reasonable than Linda, which was not saying much, but at least he understood actual law rather than just HOA power fantasies. While we waited for Robert, Linda tried a different approach. "Marcus, be reasonable. This fire pit will increase property values for everyone in the subdivision. It will be a beautiful gathering space for families, for community events." "Do you really want to be the person who ruins that for everyone?" "Linda, be reasonable," I countered. "You built on my property without permission. You violated my property rights. The fact that you had good intentions does not change the fact that what you did was wrong and illegal. If someone broke into your house but left it cleaner than they found it, would that make the breaking and entering okay?" "That is not the same thing at all," she sputtered. It is exactly the same thing, I said. Unauthorized entry and use of private property. The scale and intention might be different, but the legal principle is identical. Robert arrived about 30 minutes later, looking considerably less put together than his usual courtroom appearance. He was wearing jeans and a polo shirt, and I got the impression Linda had called him away from his own Saturday plans. He spent several minutes conferring with Linda, examining both her documents and mine, and then walked the property line, finding the survey markers. When he returned, his expression was grim. "Linda, he is right. This is private property. The subdivision plat you are using is outdated from before several lots were resurveyed and adjusted. The current filed documents show this land belonging to Mr. Webb's lot." Linda looked like she had been slapped. "That cannot be right. We checked the maps." "You checked old maps," Robert said. "The county records are clear. This is his land." He turned to me. "Mr. Webb, I apologize for this error. Obviously, this was a mistake on the HOA's part. We will cease all work immediately and remove the equipment and materials from your property." "I appreciate that," I said, relieved that the attorney at least understood the situation. "And I expect the HOA to restore my property to its original condition, filling in that pit and regrading and reseeding my lawn." Linda made a choking sound. "Do you have any idea how much that will cost?" "Considerably less than it would have cost if you had finished the entire project before discovering it was on the wrong property," I pointed out. "Consider it a cheap lesson in due diligence." Robert nodded. "We will take care of the restoration. I will draft the work order this afternoon." I thought that was the end of it. I was wrong. 2 days later, I came home from work to find the pit still there, but now with a chain-link fence around it and a sign that read, "Future Community Fire Pit Saguaro Springs HOA." The materials were still stacked nearby, and it was clear that while work had not continued, nothing had been removed or restored either. I called Robert's office and left a message. Then I called the HOA management company and left another message. Neither call was returned that day. By the end of the week, I still had a giant pit in my backyard, still had construction materials littering my property, and still had not received any communication from the HOA about restoration. I sent certified letters to both Robert and the HOA board, documenting the situation and demanding action within 10 business days. The response I received was not what I expected. Instead of an apology or a restoration timeline, I received a letter from the HOA informing me that they were moving forward with the fire pit project and that my frivolous objections were overruled by the board. The letter went on to say that the board had voted to proceed with the project and that I could appeal their decision at the next monthly meeting. I read the letter 3 times, barely believing what I was seeing. They were not just ignoring my property rights, they were actively dismissing them and claiming authority they did not have. The next HOA meeting was 2 weeks away, but I was not going to wait that long. If they wanted to play hardball, I could play too. I spent the weekend researching landscaping companies and getting quotes. Then, on Monday morning, I took a personal day from my job as an aerospace engineer at a local defense contractor and made some calls. By Tuesday afternoon, I had a dump truck full of clean, filled dirt backing into my yard. The truck driver looked at the pit and whistled. "You want me to fill all of that?" "Every last inch," I said. "And I want it compacted properly so it does not settle unevenly." Over the next 4 hours, load after load of dirt was dumped into the pit. The driver used the truck's hydraulic system to compact each layer, and by the time he finished, my backyard was level again. The job cost me $1,800, but it was worth every penny. I had the contractor's crew remove the chain-link fence and stack all of the HOA's materials neatly at the edge of my property line, right where my land met the actual common area. Then, I had a landscaping company come out to reseed the filled area and restore the disturbed ground. I documented everything with photographs and videos, showing the pit, the filling process, the finished restoration, and the HOA materials now sitting on their own property rather than mine. The reaction was swift and explosive. Linda called me that evening, her voice shaking with rage. "What have you done? You destroyed thousands of dollars worth of work." "I restored my property," I said calmly. "You had 2 weeks to do it yourselves after being informed of your error. You chose not to. You chose instead to continue claiming you had a right to my land. So I took care of the problem myself." "You will pay for this," Linda hissed. "The HOA will sue you for the cost of that excavation work, for the materials, for everything. You just made the biggest mistake of your life." "I look forward to seeing you in court," I said. "Make sure you bring documentation of your authority to seize private property. I am sure the judge will be very interested in that." She hung up on me. 3 days later, I received a notice that I was being fined $5,000 for unauthorized modification of community property and interference with approved HOA projects. The notice also informed me that I was being sued for damages in the amount of $37,000. I called Robert's office again. This time his secretary put me through immediately. "Mr. Webb," Robert said, sounding tired, "I tried to convince them not to do this." "Then you know they do not have a case," I said. "I know they should not have a case," Robert corrected. "But Linda is convinced that because the original subdivision plat showed that area as common space, the HOA has a grandfathered right to it. She is not listening to me about the updated surveys." "So you are going to take this to court even though you know you will lose?" I asked. Robert sighed. "I am the HOA's attorney. I represent their interests even when I think they are making a mistake, but off the record, Mr. Webb, you should get your own lawyer. This is going to get ugly before it gets better." I thanked him for the candor and hung up. Then I started researching property rights attorneys. I found an excellent lawyer named Patricia Hernandez who specialized in property disputes and HOA conflicts. Her office was in Scottsdale, and when I met with her and showed her my documentation, she actually smiled. "This is one of the clearest property rights cases I have seen in years," she said. "Not only did they build on your property without permission, but they are now attempting to claim ownership of land they never had title to, and they are trying to fine and sue you for protecting your own rights." "This is going to be fun." "Fun is not the word I would use," I muttered. "Trust me," Patricia said. "When the other side is this clearly in the wrong, these cases become very straightforward. The only question is how much this is going to cost them in the end." We filed a response to the HOA's lawsuit, along with a countersuit for trespassing, property damage, harassment, and abuse of authority. We also filed a complaint with the Arizona Department of Real Estate, which oversees HOA operations, documenting the HOA's actions. The HOA meeting where they planned to address my violations was scheduled for a Thursday evening in late March. Patricia advised me to attend and to let them dig themselves deeper. I arrived at the community center to find it more packed than I had ever seen it. Apparently, word had spread about the dispute, and my neighbors were curious. Some were probably on the HOA's side, believing I was being difficult. Others had their own grievances with Linda's authoritarian management style and were hoping to see her taken down a peg. Linda called the meeting to order and immediately launched into the fire pit issue. As everyone knows, we have been working on a beautiful new community fire pit area that will serve as a gathering space for our neighborhood. Unfortunately, one resident has decided that his personal preferences are more important than the good of the community. I raised my hand. "Point of order, Madam President. You are mischaracterizing the situation." Linda glared at me. "You will have an opportunity to speak when I am finished." "Actually," I said, standing up, "I have a right to respond to false statements being made about me in a public forum. You are not describing a difference in preferences. You are describing a property rights dispute in which the HOA built on my private land without permission." Several neighbors murmured, and I could see some of them pulling out their phones. probably looking up their own property boundaries to make sure the HOA was not encroaching on their land too. Linda's face was red. The board has determined that the land in question is common area property and that your survey is incorrect. The board does not have the authority to determine property boundaries, I said. That is determined by licensed surveyors and recorded with the county. Your personal opinion about where the boundaries should be is irrelevant to the legal reality of where they actually are. This is not a debate, Linda snapped. The board has voted to proceed with the fine and the lawsuit. That is final. A hand went up in the back. It was Tom Reeves, a retired engineer who lived 3 streets over. Linda, can I see the documentation showing that the land is common area? Because if Marcus has a filed survey saying it is his, I would like to know what documentation the HOA has to contradict that. Linda shuffled papers. We have the original subdivision plat from 2002. So you have a 24-year-old map and Marcus has a current survey? Tom said. That does not seem like a strong position. The attorney has reviewed our position and filed the lawsuit, Linda said defensively. Has the attorney told you what he thinks your chances of winning are? Another neighbor asked. Linda did not answer that question. The meeting continued with various other HOA business, but the fire pit dispute had clearly become the main topic of neighborhood gossip. Several neighbors approached me afterward, some offering support, others just wanting to hear the details. A few admitted they had their own concerns about HOA overreach and were glad someone was finally pushing back. As I was leaving, Robert Chen pulled me aside. Mr. Webb, I want to make one more attempt at settlement before this goes any further. Would you be willing to meet with me and Linda to discuss options? What options? I asked. My position is simple. The HOA trespassed on my property and I corrected that situation. They need to drop the fine and the lawsuit and we can all move on. What if the HOA formally apologized and withdrew all actions against you? Robert asked. Clean slate, everybody walks away. I would accept that, I said, but I am not paying for the dirt I used to fill the pit. That was the HOA's responsibility to begin with. Understood, Robert said. Let me talk to Linda. That conversation apparently did not go well. 2 days later, I received an amended complaint increasing the damages the HOA was seeking to $55,000 and adding a claim for intentional infliction of emotional distress on behalf of Linda personally. Patricia laughed when I showed her the updated complaint. They are panicking. This emotional distress claim is frivolous and borders on sanctionable. They know they are losing on the property issue, so they are trying to overwhelm you with inflated claims. It will not work. The case was assigned to Judge Michael Thornton in Maricopa County Superior Court. The initial hearing was set for early May, which gave both sides time to complete discovery and file motions. During discovery, Patricia subpoenaed all of the HOA's records related to the fire pit project, including the board meeting minutes where it was approved, any surveys or property assessments they had conducted, and all correspondence related to the project. What we found was illuminating. The HOA had never conducted a survey of the site. They had simply looked at the old subdivision plat and assumed it was accurate. Multiple board members had raised questions about whether they should verify the property boundaries, but Linda had dismissed those concerns, saying it was unnecessary and would just delay the project. Even more damning, after Robert had confirmed that my survey was correct and the land was indeed my property, Linda had called an emergency board meeting and convinced the other members to proceed anyway. The minutes from that meeting included a discussion where Linda argued that the HOA should claim the land through adverse possession or community easement rights, neither of which applied to this situation. Patricia was delighted. This shows deliberate disregard for your property rights even after they knew they were in the wrong. This is going to make the countersuit very strong. We also discovered that Linda had been shopping around for a different attorney after Robert had advised against continuing the lawsuit. She had apparently contacted 3 other lawyers, all of whom had turned down the case after reviewing the facts. The HOA filed a motion for summary judgment, asking the judge to rule in their favor without a trial based on the argument that the original subdivision plat gave them permanent rights to the disputed area. Patricia filed our own motion for summary judgment based on the clear property records showing my ownership. The hearing on both motions was scheduled for May 12th, and both sides were ordered to appear. Linda was planning to represent the HOA's interests, with Robert presenting the legal arguments. But then something interesting happened. About a week before the hearing, I got a call from Patricia. "You are not going to believe this," she said, barely containing her excitement. "The HOA filed their motion with the wrong judge." "What do you mean, the wrong judge?" I asked. "Judge Thornton is assigned to our case number CV 2026 to 004523. The HOA filed their summary judgment motion under case number CV 2026 to 004532, which is a completely different case assigned to Judge Patricia Ramirez. It is a construction defect case involving a different HOA entirely. They got the case number wrong on all their filings." I started laughing. "You are kidding." "I am not," Patricia said. "And here is the best part. Judge Ramirez's clerk contacted our case to figure out why they were getting HOA filings about a fire pit when their case is about roof leaks. The clerk forwarded everything to Judge Thornton's chambers, but technically, the HOA never properly filed their motion in the correct case. They missed the deadline." "So what does that mean?" I asked. "It means their motion for summary judgment is void. They did not file it in time in the correct case. Our motion is still valid. If Judge Thornton agrees with our position, and I think he will, he could grant our motion and rule that you are entitled to judgment on the HOA's claims against you and potentially on your counterclaims." This was almost too good to be true. After months of stress and legal fees, the HOA had sabotaged their own case through sheer incompetence. The hearing on May 12th was in a surprisingly small courtroom. Judge Thornton was a man in his early 60s with gray hair and a reputation for not tolerating nonsense. He had reviewed all the filed motions and the discovery materials before the hearing. Patricia and I sat at the plaintiff's table, while Robert and Linda sat at the defendant's table. Linda kept whispering urgently to Robert, who looked increasingly uncomfortable. Judge Thornton called the case and looked at both sides. "Before we begin, I need to address a procedural issue. Mr. Chen, your client filed a motion for summary judgment but filed it in the wrong case." "Are you aware of this?" Robert stood. "Yes, Your Honor, that was an unfortunate clerical error. We would ask the court's indulgence to allow us to refile the motion." "The deadline for filing that motion was April 28th, Judge Thornton said. "Today is May 12th. You are asking me to overlook a missed deadline." "Due to circumstances beyond our control, Your Honor," Robert said. Judge Thornton looked skeptical. "Mr. Chen, somebody in your office typed the wrong case number on multiple documents and filed them in the wrong case. That is not circumstances beyond your control. That is just getting the case number wrong. Do you have any case law supporting my authority to grant your motion to file out of time?" Robert shifted his weight. "Your Honor, in the interests of justice, deadlines matter," Judge Thornton interrupted. "They exist for a reason. If I allow you to file late because you made a mistake, then I have to allow everyone to file late when they make mistakes, and then the deadlines are meaningless. Unless you can show me exceptional circumstances, your motion is denied." Linda stood up, which was a mistake. "Your Honor, this is ridiculous. We are being penalized for a simple error." "Miss Morrison, are you an attorney?" Judge Thornton asked. "No, but I am the HOA president." "Then please sit down. Mr. Chen represents the HOA and only Mr. Chen will address the court." Linda sat, her face purple with rage. Judge Thornton turned his attention to Patricia. Miss Hernandez, I have reviewed your motion for summary judgment. Do you have anything to add to your written arguments? Patricia stood. No, Your Honor. We believe the facts are clear from the evidence submitted. The plaintiff has documented ownership of the property in question through multiple surveys filed with the county. The HOA constructed on that property without permission and then sued the plaintiff when he restored his own land to its original condition. There are no genuine disputes of material fact, and the plaintiff is entitled to judgment as a matter of law. Judge Thornton nodded, flipping through the documents in front of him. Mr. Chen, I have read the HOA's complaint and the various filings. Putting aside the procedural issues with your motion, can you point me to any evidence that the HOA has ownership rights or easement rights to the property in question? Robert stood again. Your Honor, the original subdivision plat from 2002 designated that area as common space. And has that plat been superseded by subsequent surveys and property descriptions? The judge asked. Yes, Your Honor, but our position is that the original designation should control. On what legal basis? Judge Thornton asked. If a property is surveyed and the survey is recorded with the county, and that survey shows different boundaries than an older plat, does not the more recent survey control? Generally, yes, Your Honor, but is there an easement recorded against Mr. Webb's property giving the HOA rights to use that portion of his land? No, Your Honor. Is there any deed restriction that would prevent Mr. Webb from filling in a hole on his own property? Not specifically, Your Honor, but the HOA covenants give the association broad authority. To do what exactly? Judge Thornton interrupted. To seize private property, to construct improvements on land the HOA does not own, to fine homeowners for protecting their own property rights. Robert was silent for a moment. Your Honor, perhaps this matter would be better suited for a trial where all the nuances can be explored. Judge Thornton shook his head. I do not see any nuances here, Mr. Chen. I see a very straightforward case. The HOA built something on private property without permission. The property owner removed it. The HOA is now trying to punish the property owner for exercising his legal rights. This is not a close case. The judge looked down at his notes, then back up at both attorneys. Here is my ruling. The plaintiff's motion for summary judgment is granted. The HOA's claims against Mr. Webb are dismissed with prejudice. The HOA is ordered to pay Mr. Webb's attorney fees incurred in defending against this action. As to Mr. Webb's counterclaims, I am granting summary judgment on the trespassing and abuse of authority claims. The harassment claim and the request for punitive damages will need to be addressed at a further hearing where I can take testimony on the extent and impact of the HOA's conduct. Linda made a strangled sound, and Robert put a hand on her arm to keep her from speaking. The HOA is also ordered to remove all materials from Mr. Webb's property within 72 hours, Judge Thornton continued. And Miss Morrison, the court notes that you personally added a claim for intentional infliction of emotional distress. That claim is not only dismissed, but I am awarding sanctions against the HOA in the amount of $2,000 payable to Mr. Webb for filing a frivolous claim. Consider yourself fortunate I am not awarding more. He banged his gavel. We will reconvene in 30 days for a hearing on the remaining counterclaims. In the meantime, the HOA is to have no contact with Mr. Webb except through counsel, and all fines and violations issued against him in relation to this matter are hereby voided. This case is adjourned. Patricia and I stood as the judge left the courtroom. I felt a wave of relief wash over me. It was not complete victory yet, but it was vindication of everything I had been saying for months. Linda stormed out of the courtroom without looking at us. Robert gathered his papers slowly, then approached our table. Congratulations, he said quietly. For what it is worth, I tried to tell them this was a bad idea. I know you did, I said, and I appreciate that you were at least honest about it. Robert nodded and left. Patricia and I walked out together, and once we were outside the courthouse, she turned to me with a huge grin. "That was even better than I hoped," she said. "The sanctions were a nice touch, and the judge's comments about the case being straightforward, that is going to make the rest of this very easy." "What happens now?" I asked. "We prepare for the hearing on your damages claims," Patricia said. "You are entitled to compensation for your time, for the cost of filling in the pit, for the stress and harassment you have endured. We document everything and present it to the judge. My guess is the HOA will try to settle before that hearing happens." She was right. 2 weeks later, Robert called her to discuss settlement terms. The HOA was offering to pay my attorney fees and the $1,800 I had spent on fill dirt, plus drop all fines and violations if I would drop my remaining claims. Patricia called to discuss it with me. "It is your decision, but I think we could get more if we go to the hearing. The harassment claim alone could be worth $10,000 to $15,000, and there is a possibility of punitive damages given how egregious their conduct was." I thought about it. Part of me wanted to push for maximum damages to make the HOA pay for every bit of stress and aggravation they had caused. But another part of me just wanted to be done with the whole situation. "What are my attorney fees at this point?" I asked. "About $12,000, Patricia said. "Which they are obligated to pay based on the judge's ruling. And if we go to the hearing for the other claims, how much more in attorney fees will I rack up? Probably another $4,000 to $6,000, depending on how much preparation is needed and how long the hearing lasts." I made my decision. Counteroffer. They pay my attorney fees, they pay the $1,800 for the dirt, they pay an additional $10,000 in damages for harassment and abuse of authority, and they issue a written apology to be included in the next HOA newsletter admitting they were wrong. If they accept those terms, I will drop the remaining claims. Patricia was quiet for a moment. "That is actually very reasonable, almost too reasonable. Are you sure?" "I am sure," I said. "I do not need to bankrupt the HOA. I just need them to acknowledge they were wrong, compensate me fairly, and ensure this does not happen to anyone else in the neighborhood." Patricia presented the counteroffer to Robert, and after a week of back and forth, the HOA board accepted. The settlement was formalized in a written agreement, and the case was closed. The written apology appeared in the June newsletter, though it was clearly painful for Linda to approve. It read, "The Board of Directors of the Saguaro Springs HOA acknowledges that errors were made in the planning and execution of the community fire pit project. We incorrectly identified the location for the project and began construction on private property belonging to Marcus Webb without his permission. We further erred in our response to Mr. Webb's legitimate objections and in pursuing legal action against him. The board apologizes to Mr. Webb for these errors and for any distress caused. The board is implementing new procedures to ensure proper verification of property boundaries before any future community projects are undertaken." It was not quite the full mea culpa I might have hoped for, but it was something. The real victory came 2 months later, at the HOA annual meeting where board members were up for election. Linda had served as president for 6 years, but her handling of the fire pit disaster had destroyed her support in the community. 3 other board members who had voted to continue the lawsuit also faced challenges. I did not run for the board myself. I had no desire to spend my evenings in HOA meetings. But I did support a slate of candidates who were committed to more transparent and reasonable governance. On election night, Linda and 2 of her allies were voted out, replaced by level-headed neighbors who understood the difference between enforcing reasonable rules and authoritarian overreach. The new board president was Tom Reeves, the retired engineer who had questioned Linda at that contentious meeting. His first act was to commission a comprehensive survey of all common areas to ensure the HOA's maps were accurate and up-to-date. His second act was to establish a new policy requiring any proposed construction project to include verification of property boundaries, by a licensed surveyor before work began. The fire pit project was eventually completed, but in its proper location on actual HOA common ground, about 50 yards south of where they had originally tried to build it. I attended the opening ceremony, which was a pleasant evening gathering with my neighbors. Several people thanked me for standing up to the HOA, and a few shared their own stories of Linda's overreach over the years. Linda herself moved out of the subdivision 3 months after the election, selling her house and relocating somewhere in California. I heard through the neighborhood grapevine that she was bitter about how things had turned out, convinced that she had been treated unfairly. I did not waste any energy on sympathy. She had brought it on herself through arrogance and a refusal to admit error even when the facts were clear. The legal fees the HOA paid me totaled just over $12,000. The $1,800 for the dirt was reimbursed. The $10,000 in damages went partly to offset my time and stress, and partly into a savings fund for future home improvements. I considered it a windfall and a lesson learned about the importance of documentation and standing firm on principle. Robert Chen sent me a brief note after the settlement was finalized. It said simply, "You were right, and I am glad the system worked the way it should have. Good luck with your property." I appreciated the acknowledgement, even if it came a bit late in the process. My backyard recovered nicely from the whole ordeal. The grass grew back thick and green over the filled area, and by late summer you could not tell anything had ever been disturbed. I installed a small garden area where the pit had been, planting tomatoes and peppers and herbs. It seemed fitting to turn the site of the conflict into something productive and peaceful. I kept all the documents from the case in a file box, just in case, but I never needed them again. The new HOA board was professional and reasonable in all our interactions. Violation notices became rare and were only issued for genuinely problematic situations. The Architectural Review Committee approved reasonable requests without arbitrary denials. The neighborhood settled into a calmer rhythm. One Saturday morning in September, I was working in my garden when Tom stopped by. He lived just around the corner, and we had become friendly since he took over as board president. "Looking good," he said, gesturing at the garden. "Hard to believe this was ground zero for World War III just a few months ago," I laughed. "Hopefully the only war happening here now is my battle against aphids." Tom smiled, then grew more serious. "I wanted to thank you again for what you did, I mean it." Linda had been running roughshod over this neighborhood for years, and nobody had the energy or the resources to push back effectively. "You did not just win your case, you changed the whole dynamic of how the HOA operates." "I just protected my property," I said. "Anyone would have done the same." "Actually, no," Tom said. "A lot of people would have been intimidated by the legal threats and the fines and would have backed down, or they would have gotten so angry that they escalated things unnecessarily. You kept your cool, you documented everything, you followed the proper procedures, and you won. That takes a particular kind of person." I shrugged, uncomfortable with the praise. "I had a good lawyer." "You made good decisions," Tom corrected, including the decision to settle reasonably instead of pushing for maximum damages. That showed maturity and helped the neighborhood move forward instead of remaining divided. After Tom left, I sat on my back deck with a cold drink, looking out over my property. The surveyor's iron stakes were still there, marking the corners of my lot. They seemed almost symbolic now, representing not just property boundaries but the importance of clear rules and respect for individual rights. The whole experience had taught me several things. First, documentation is everything. If I had not had that survey, if I had not kept copies of every correspondence, if I had not photographed and videoed everything, the case would have been much harder to win. Second, standing on principle sometimes means accepting short-term costs for long-term vindication. The $1,800 for the dirt had been a calculated gamble that paid off. Third, the legal system, for all its flaws and frustrations, does work when you have the facts on your side and the patience to see it through. I also learned something about HOAs specifically. They are not inherently bad institutions. They can serve valuable functions in maintaining property values and managing common areas. But they require oversight and accountability. When board members start believing they have unlimited authority, when they stop listening to homeowners, when they let personal egos drive decision-making, they become destructive forces. The remedy is active participation by homeowners, voting in reasonable people, and when necessary, legal challenges to check abuse of power. My neighbors learned something too. In the weeks and months after the settlement, I heard about several other homeowners who had been dealing with questionable HOA actions. A couple whose fence had been repeatedly cited even though it met all the specifications. A family who had been denied approval for solar panels based on aesthetic concerns that were not in the actual covenants. A retiree who had been fined for parking his RV in his own driveway overnight, even though the restriction was supposed to only apply to street parking. In each case, the homeowners had assumed the HOA was right and they were wrong, simply because the HOA claimed authority. After seeing how my situation played out, they started questioning those assumptions and asking for documentation of the rules being enforced. In most cases, the new board quickly resolved the issues once they reviewed them with fresh eyes. The neighborhood dynamics shifted in other ways too. The monthly board meetings, which under Linda had been sparsely attended affairs where decisions were rubber-stamped, became actual community forums. Homeowners showed up to ask questions, offer input, and monitor how their fees were being spent. The transparency was healthy, even if it made the meetings longer and sometimes more contentious. I attended a few of those meetings, though I tried not to be a constant presence. I did not want to be seen as a gadfly or someone with a vendetta, but I made a point of showing up when major decisions were being discussed, and I encouraged other neighbors to do the same. An engaged community was the best protection against future abuses. In October, the HOA hired a new management company after the previous one's contract expired. The new company was smaller but had a reputation for professionalism and for understanding the legal limits of HOA authority. They implemented better record-keeping systems, clearer communication with homeowners, and training for board members on their roles and responsibilities. One of the new procedures required the HOA to carry liability insurance specifically covering errors in board decision-making. It was a prudent move that would protect homeowners from bearing the costs if the board made another expensive mistake. The fire pit itself became quite popular once it was completed in the correct location. On cool desert evenings, families would gather there, and the space became what Linda had originally envisioned, a community gathering point. The irony was not lost on me. If she had simply done her due diligence in the first place, checked the property boundaries and built it where it belonged, she would have gotten credit for a successful project. Instead, her impatience and arrogance turned a potential win into a humiliating defeat. I used the fire pit myself on occasion, joining neighbors for s'mores and conversation under the stars. Nobody seemed to hold any grudges about the conflict. If anything, people were friendlier than before, united by a shared sense that the neighborhood was in better hands. As the year wound down toward the holidays, I reflected on how much had changed. What had started as a shocking discovery of unauthorized construction on my property had turned into a legal battle, a political upheaval in the HOA, and ultimately a positive transformation of how the neighborhood was governed. I could have handled things differently at various points. I could have been more confrontational, demanding criminal charges for trespassing. I could have sought maximum damages and tried to bankrupt the HOA. I could have run for the board myself and tried to directly control the outcome. But I chose a more measured approach, asserting my rights firmly but not vindictively, and trusting the legal system and democratic process to deliver justice. That approach had worked, and I was proud of how I had handled things. More importantly, I had helped create positive change that would benefit my neighbors for years to come. That was worth more than any damage award. My story spread beyond just my immediate neighborhood. Patricia told me she had received several calls from other homeowners in different subdivisions who were dealing with similar HOA problems and wanted representation. Apparently, my case had become something of a reference point in local property law circles as an example of HOA overreach and how to effectively challenge it. I even got a call from a local news reporter who wanted to do a story about HOA abuses. I politely declined. I had no interest in becoming the public face of HOA reform or in rehashing the details of the conflict for public consumption. I had achieved what I needed to achieve, and I was content to let it rest. The only media I did participate in was a brief quote for a neighborhood newsletter article about the importance of understanding your property boundaries. I emphasized the value of having a current survey and knowing exactly where your lot lines are, especially if you are planning any construction or landscaping near the edges of your property. It was practical advice that hopefully would prevent others from facing similar disputes. As winter settled in, I spent weekends working on indoor projects and planning for the next growing season in my garden. The filled area had settled well, and I was considering expanding the garden slightly into what had previously been just lawn. It was a small silver lining from the whole ordeal. I had been forced to think more carefully about how I used my backyard space, and I had come to appreciate it more. Christmas brought neighborhood decorations and friendly competition over light displays. The HOA, under its new leadership, had relaxed some of the more stringent rules about holiday decorations, allowing more creativity while still maintaining basic standards of taste and safety. My own display was modest but festive, and I enjoyed driving through the neighborhood in the evenings to see what others had done. At the neighborhood holiday party, hosted at the community center, I found myself chatting with Robert Chen, who attended as a guest of one of the board members. We had not spoken since the settlement was finalized. "How are things?" he asked, somewhat awkwardly. "Good," I said. "Better than they were a year ago at this time. How about you?" "Busy," Robert said. "Always busy. But I wanted to tell you that I learned something from your case. I have been practicing HOA law for 15 years, and I think I had gotten a bit too comfortable representing associations without questioning whether what they wanted to do was right, not just whether it was defensible. Your case reminded me that my job is not just to advocate for my client but to provide good counsel. Sometimes that means telling them they are wrong." "That is a healthy realization," I said, "and for what it is worth, I never thought you were the problem. You were just trying to do your job in a difficult situation." "I appreciate that," Robert said, "and I am glad things worked out the way they did. This neighborhood is better off for it." We shook hands, and I felt a sense of closure. The conflict had been resolved not just legally but personally. There were no lingering grudges, no ongoing animosity. Everyone had moved on. As I drove home that evening, passing houses decorated with lights and the community fire pit where a few families were gathered despite the chill, I felt genuinely content. My property was mine, secure and undisputed. My neighborhood was well governed. My relationships with my neighbors were positive, and I had learned valuable lessons about standing up for my rights and navigating conflict effectively. The story could have ended much worse. If I had reacted with pure anger instead of strategic thinking, if I had not had the resources for good legal representation, if the judge had been less clear-eyed about the law, the outcome might have been different. But things had worked out, and I was grateful for that. In January, I received the final check from the HOA, closing out the settlement. I deposited it and immediately wrote a check to Patricia for her remaining fees. We were square, and the chapter was truly closed. I framed one thing from the whole experience. A copy of Judge Thornton's order granting my motion for summary judgment, not to gloat, but as a reminder. A reminder that property rights matter, that documentation matters. That standing firm on principle, even when it is difficult and expensive, sometimes pays off. And that justice, while sometimes slow, is still achievable. That framed order hangs in my home office where I can see it when I am working. It is not prominent, just there on the wall among other personal items. But every time I glance at it, I remember those months of conflict and uncertainty, and I remember how they resolved. I remember Linda's red face when the judge dismissed her claims. I remember the moment I signed the settlement agreement. I remember the first tomato I harvested from the garden I planted where they had tried to build their fire pit. Most of all, I remember that I had won not through aggression or luck, but through preparation, documentation, and faith in the system. That felt like the right kind of victory, the kind that left me with my integrity intact and my property secure. Years from now, when the whole incident is a distant memory, I suspect I will still have that framed order on my wall. It will be a conversation piece, a story to tell to guests who notice it and ask what it is about. And I will tell them about the time the HOA built a fire pit on my property. I filled it with dirt, and they complained to the wrong judge. It is a good story with a satisfying ending, and I am glad I lived through it to tell it.